17 years ago, the illusion of security in the United States from international terrorism was changed forever. Americans were forced to recognize their vulnerability, and terrorism was a problem that occurred abroad, and now it's occurring in the United States. And the government responded quickly to the 9/11 attack, and one aspect of the response was the Victims' Compensation Fund that Congress established 11 days after the attack, and that's my focus today. The fund served several purposes. It protected the airline industry from potentially crippling liability. It provided financial assistance to victims and their families, and it helped restore the faith of the people and the ability of the government to protect the public. As we know, the United States hasn't suffered a terrorist attack on the same scale since then, although smaller attempts have occurred and aborted too. But our view at the same time of defining terrorism has evolved and become more nuanced. We once viewed it solely as a foreign invasion on our land, but now we have attacks perpetrated by U.S. nationals, like the Boston Marathon bombers and lone wolf attacks with loose or ambiguous connections to international terrorist organizations like Nidal Hassan at Fort Hood. So I examine today the question of establishing a permanent victims' compensation fund in the United States, like Israel and other countries have done. I'm going to speak to the United States experience, but I hope my comments have broader applicability. First, I'll very briefly examine the 9/11 fund, and then next I'll discuss the purposes and rationales that underlie the establishment of a permanent fund and conclude that it makes sense to do so. I'm happy to give some recommendations for the creation of a permanent fund in Q&A. So the 9/11 fund was, as I said, part of emergency legislation. It was only intended to address the 9/11 attacks. The same act gave protections to our airline industry, including federal loan guarantees of up to $10 billion, compensation for direct losses from a stop order, ground stop order. The airlines and the American Trial Lawyers Association, surprisingly, both called for a compensation program that would shield the airlines from liability. And the act created a compensation system that would coexist with the tort system, capped the airline liability at the maximum amount of its liability insurance. The act provided for a special master to be appointed by the Attorney General to administer the fund. We all very well know that Ken Feinberg became that special administrator. But the statute didn't provide much guidance or any judicial oversight, and it's actually remarkable how much discretion Feinberg had. He was basically given a blank check to act as a judge and a jury in distributing the compensation. So he first went about establishing regulations to define what an eligible claimant was and what projected awards would be. So he, for example, interpreted eligible claimants as those who sought medical treatment within 72 hours. It didn't recognize people with latent injuries, although later in 2011 that was changed, and in fact some claims were recognized there. The awards were limited to physical harm, to death, no property loss. He said that foreign applicants were eligible, and he looked to the individual state or domicile to see whether a fiancé would be recognized or a same-sex partner would be recognized as well. Amazingly, there was no statutory limit to the amount of compensation, either on an individual basis or in total, that would be allocated to the fund. So Feinberg himself, and I understand he's come here and spoken, so you probably heard him talk about this, he himself decided to limit the monetary amount of awards. And so he used a traditional tort theory of replacement damages for lost income, but he charged himself with what he called social engineering. And he said that he didn't want too much disparity between the high-end earners and the low-end earners. He published a table of awards, which of course was promptly challenged by the high-end earners, but this was upheld by the courts, and that created a presumptive award formula based on annual salary, age of the victim, number of dependents. He also imposed a standard $250,000 for non-economic loss or pain and suffering. And he said that all awards would be offset by collateral sources, meaning basically insurance, life insurance funds. So what he did was he created a hybrid system that incorporated principles of equity and equality. It's a hybrid tort and a no-fault compensation system. He had complete discretion over administration of the fund, over the process of administering the fund. He offered free legal advice for those who wanted it, but anybody who opted for the fund would then have to waive their right to file a claim and sue in court. So the fund was considered a success on its own terms. Over 97% of the eligible victims filed claims with the fund. Ultimately, over $7 billion was distributed. Only 94 claimants out of about 7,000 went to the courts, and eventually they settled their claims, although this took several years. So the fund gave families a sense of closure and the ability, presumably, to begin to move on. Here's a quote from Feinberg. "I believe the fund can be fairly considered the valedictorian of all compensation programs, public or private." And yet, some criticisms emerged. The fund failed to articulate a coherent theory of justice. It didn't provide a mechanism to review the special master's discretion. It was under-inclusive because it didn't include victims of other terrorist incidents or crimes or accidents. Feinberg himself has said repeatedly that we should never repeat the fund. It's not a sustainable precedent for the future. He says it's too hard to define what type of attacks or disasters should receive government compensation, which type of industries merit protection from the civil liability system. Basically, it's hard to figure out when to do an end run around our tort system and have the government step in. And here's another final quote from Feinberg. "Heaven forbid it happens again. Should we replicate this program in some way? You justify a program like this not by examining the status of the victim, but by looking at the nation's response, the collective will of the people concerning 9/11 and the impact of 9/11 on the country. This is like Pearl Harbor, the assassination of President Kennedy, or the American Civil War. 9/11 was unique and gave rise to a unique response. That is the only way, I think, to explain it." This leads to the question, is it a government's responsibility to ensure compensation to victims of terrorism? And if it is, should it be accomplished on an ad hoc basis, as is currently the American approach, or a permanent fund designed to address multiple situations, as you see in Israel? So I examined briefly some theoretical justifications for creation of a permanent fund. In the United States, we traditionally deal with loss in society culpably caused by others through our civil justice system. We think of the underlying rationales of the U.S. justice system as promoting the values of deterrence and corrective justice. This includes that duty of repair that restores the party to the pre-injury position. Secondary effects from our tort system include vindication, potential for policy change, access to information, acknowledgement of harms, and accountability. But we do have some exceptions to this, and we bypass the civil justice system in the United States sometimes. The main rationale behind these bypass systems are programs like the United States Nuclear Accident Compensation Program or the Vaccine Injury Fund, and basically the idea is to spread loss among society or distributive justice. This is a risk-sharing policy stemming from principles of fairness to ensure that no one individual bears the cost of loss in these situations. Secondary purposes are served by government compensation funds, such as the protection of certain critical industries, like the vaccine industry and the nuclear power industry, from liability costs. Or we create compensation systems like the Workers' Compensation Fund to provide an alternative to what we think of as a slow and inadequate tort system without the need to prove fault or to answer to defenses like comparative fault. Crime victim compensation programs do exist, and they reflect government compassion and generosity as well as political motivations. The justifications for the 9/11 fund, that emergency legislation, were murky at best, and Congress certainly didn't address it, and Feinberg had a struggle with what his guiding principle was in implementing the fund. One justification for creating a government compensation fund is a legal obligation based on a social contract theory, as a rights-based rationale that looks to the government as a guarantor of preventing harm. Citizens pay taxes to fulfill their end of this contract, but the United States government traditionally doesn't accept this kind of responsibility. The U.S. government launched the 9/11 Commission to investigate the attacks. The commission didn't find that the United States government caused the attacks, nor had the government ever admitted its liability in the situation. So in that sense, the fund was a choice to compensate victims as a political matter, not as a legal obligation. Another justification for a government compensation fund is a notion of shared risk. As I just mentioned, this rationale of distributive justice would spread loss more evenly among society, but this idea of burden sharing and risk spreading certainly didn't seem to be the basis of the 9/11 fund either. A third rationale for a compensation fund is based on a social welfare theory. Social welfare helps improve the lives of the people in the community, and this is probably the most widely advocated basis for government victims' compensation. It seeks equity for victims based on need. This obligation is social rather than legal or moral, and it's based on the idea that the origin of crime is social, and society as a whole is responsible for the evil that springs from it. Thus, society expects assistance when dealing with loss from these situations. And we certainly have pockets of social welfare aspects in the United States, but mostly we have a limited government and we're not accustomed to delivering welfare on a large scale. A criticism of social welfare theory is that it allows people to abandon individual responsibility for the harm. Other people argue that it's paternalistic. Feinberg doesn't seem to have relied on this theory, social welfare theory, either as the underlying justification for the 9/11 fund, because he relied on equitable principles of distribution of damages, which is usually what you find in tort law, rather than the principle of treating like victims equally. Practical reasons can support the creation of a compensation fund. The 9/11 fund was clearly motivated by protecting certain industries from overwhelming liability costs. Congress determined very quickly, with a lot of lobbying on the part of the airline industry, that keeping the airline industry afloat was critical to our national interests. It later passed the Terrorism Risk Insurance Act, which still is viable, and it's been extended to 2020. This law is a secondary insurance program designed to create an incentive for insurance companies to continue to insure against losses due to terrorism, and will reimburse insurance companies for large-scale payments. Another motivation for the 9/11 fund was to create a bypass around our civil justice system. The tort system is viewed as slow, inadequate, inefficient, and doesn't work very well. The underlying rationale, as I mentioned earlier, behind our civil justice system is corrective justice and deterrence, but this was seen as unavailable in the 9/11 attacks, since the terrorists were unreachable. And other potential defendants, like the airlines, airports, insurance, World Trade Center owners, were seen as being inadequate to meet the needs of the victims. The fund was viewed as a more efficient and effective alternative to processing claims. Compassion for victims is certainly another function served by a compensation fund. This mirrors the charitable contributions given by individuals, and in that case, the public donated a gift of over $1 billion to the 9/11 victims. So all of these justifications would certainly serve to create another compensation system in the aftermath of another attack, but did they justify the creation of a U.S. compensation fund as we find in other countries? Mostly, the American public and the government are resistant to the idea of a permanent fund. The efficiencies it would create, not having to recreate a new fund each time, which would allow for faster processing and distribution of monies, isn't seen as a sufficient justification. This is based, of course, on the view that these attacks are so rare in the United States that a permanent fund is not justified. Whether that view stems from complacency and unrealistic expectations is one I can't answer, but I proceed with the assumption that this is so. So with that view, the time to create a permanent compensation fund is now, when we can proceed in a more deliberate way, rather than responding to emergencies on an ad hoc basis. And this would be very similar to the way we've set up federal agencies to deal with natural disasters, like the Federal Emergency Management Agency, and to deal with security risks, like the Homeland Security Agency. These agencies certainly don't work perfectly, but they're ready to address emergencies when they occur. The ability to respond quickly is essential in these situations. And so establishing a permanent fund now would allow us to assess priorities in compensation. It would provide a sense of stability. And it would allow us to discuss the difference in responses in a small-scale attack or a large-scale attack. And certainly permanent tribunals have more legitimacy than ad hoc ones. But the appeal for social stability and a quick response to social expectations of assistance don't seem to overcome the skepticism that surrounds this question in the United States. Americans have a view of limited governments, and we generally don't expect the government to aid or reimburse us for all of life's misfortunes. We don't view the government as a psychological safety net, except at the lowest levels. We don't view this as part of our social contract with government. We think compassion can be expressed in other ways and privately, like through charity. Furthermore, other countries that have permanent compensation systems have socialist governments or don't have the massive tort system with its civil jury system, punitive damages, and discovery that dominates the American compensation system. Thus, these countries don't have to contend with the public acceptance of a system that would inhibit recovery that could be larger or implemented differently under the tort system. And other countries obviously have experienced more significant and unrelenting terrorist attacks, obviously Israel. So even if we overcame our view of limited government and created a more efficient system through a permanent fund, can we justify treating victims of terrorism differently than victims of other crimes, including victims of mass shootings? And I think this is the hardest question of all for our country. Although their suffering is equally as significant and they're not any more or less deserving of compensation, here's where I think the goals of combating terrorism would come into play to justify that distinction. Terrorism, as we've been hearing all day, seeks destabilization of a nation, and so implementing a compensation system is one way to combat that effect. A permanent fund would be understood by Americans as an expression of solidarity with the victims of an attack on a nation. The government may rationally choose to single out domestic victims of foreign terrorism over victims of other harms for its largesse, and presumably people would adjust to that choice. Furthermore, another distinction is just based on practicalities. The number of terrorist victims in a large-scale attack, which is what I would advocate as the trigger for a fund, not all attacks, is potentially much larger, and the need to rapidly respond to a larger group of victims could also provide justification for a differential approach. And finally, we've already crossed that line. We've already distinguished between victims of terrorism and victims of crime in our country. All states have some form of compensation system for victims of crime, but these aren't funded through taxes. They're funded by the perpetrators, actually. The government, through the Justice Department, has some offices of victims of crime, but this doesn't give compensation to victims. There's another office that does give compensation to victims of terrorism if they're working for the United States government abroad. So basically, we should just openly acknowledge the difference in treatment that we make between victims of crime and victims of terrorism. Ironically, we've already begun to establish private, large-scale victims' compensation funds to deal with mass shootings like Parkland, Sandy Hook, Boston Marathon, Virginia Tech. And we also have started to create large-scale compensation systems for victims of mass injury. And of course, the BP oil spill, the Gulf oil spill is an example of that. So in the end, I think the most persuasive justification for establishing a permanent fund is based on a strategy to deal with the long-term effects of terrorism. And this would be one piece of the puzzle in our efforts to combat terrorism. It would help to deny the terrorists the impact on American society that they're trying to achieve. It offers some form of retaliation against the terrorists. It allows us to return to the pre-attack status quo with celerity. It would provide a statement of resolve by the nation that the country won't allow itself to be permanently injured by those who wish to injure it, and it promotes justice by compensating innocent victims who were harmed purely as a symbol of a hated government or society. So in that sense, it's really about reparations rather than compensation. And we can't accomplish that through our traditional system for compensation of injured persons, particularly the tort system. Often in terrorism, the primary tort visas are unavailable, and compensation could come inconsistently. Were they on the plane? Were they in the trade center? So forth and so on. Compensation is ordinarily very slow in the United States, and perhaps too late in a situation like a terrorist attack. And finally, the adversarial nature of tort proceedings offers perhaps the opposite of what victims need: respect, empathy, and understanding. So what values do we lose in creating a fund? I'm a firm believer in the tort system and recognize that some values and incentives may be lost. One function of the tort system is to uncover the cause and determine legal responsibility for a harm. So the government could meet this need by establishing a commission investigating the attack, as we did in 9/11. But what about deterrence and accounting and retribution? Mostly these needs aren't fulfilled by a compensation fund. What we lose in incentives for industry to develop greater protections against terrorist attack, we could perhaps make up through regulation. And since the extent of loss from terrorism is unpredictable, that traditional economic analysis of loss prevention is much more difficult to apply. We may also lose the incentive to donate to charity to aid the victims that we see now, and this is a cost that we'd probably just have to bear. We don't have to deduct from collateral sources like we did with 9/11. Finally, creation of a permanent system trades flexibility and accuracy for efficiency. Tort systems are lengthy, costly, uncertain. A fund, in theory, would offer the opposite result. So in conclusion, why should a government address this social ill rather than others through a compensation system? I think this is much more than about providing compensation. It must be viewed as part of, the war on terror. And for that reason, it makes good public policy. It allows us to more quickly restore the status quo and to respond efficiently and effectively in pursuing our security interests. This would guarantee the use of consistently applied criteria to value and compensate like claims alike, and it would help protect critical industries from crippling liability costs. Thank you. Sure.
Liability for acts of terrorism in a comparative perspective, but let me first thank you for being invited here. It's a great honor and pleasure to speak at this conference, and thank you, Ronan, for this very nice introduction. Maybe a bit too nice, I would put it more humble, but now to my topic. Like Eli Salzberger, he gave a sort of definition of terrorism, and I also want to start with that. Under the Austrian Criminal Code and similar, maybe most of the jurisdictional codes, criminal acts like murder or kidnapping can be qualified as a terrorist act if they are apt to cause a severe or a lasting disturbance of public life or economy, and if they were committed with the intent to gravely intimidate the public or to coerce public authorities or international organizations to certain actions or omissions, or to seriously impair or destroy basic political, constitutional, economic, or social structures of a state or international organization. It's self-evident in this respect that terrorists must be liable to compensate for the intentionally committed damaging criminal acts. Certainly, though, such compensation claims will often come to nothing, because the terrorists will be without sufficient property, will be in prison, or, in particular with suicide attacks, will have died without leaving any valuable estate. For the victims of terrorist attacks, The question thus arises, under what conditions legal subjects other than the terrorists can be made liable? Conceivable bases for a claim here include fault-based and strict liabilities. Let us first turn to fault-based liability. It's generally recognized that terrorists are fully liable for their intentional harmful acts, but as noted, it's generally not possible to implement such liabilities. At least in some cases, therefore, it looked promising to target the assets of a terrorist organization supporting the ultimate wrongdoers. If an attack is directly supported by such an organization, it's not difficult to extend the chain of causation and to establish liability. The same is true if a member of a terrorist group engages in illegal activity which is not specifically directed by the organization, but is covered by the organization's general scheme or strategy. Moving another step further away, liability may possibly still be triggered by the mere sponsoring of terrorists. Again, it seems unproblematic to bring such sponsors into play if they were aware of the use being made of their funds. The quite famous US case Boehm versus Quranic Literary Institute may serve as an example here. In 1996, David Boehm was killed by Hamas terrorists in Israel. In the aftermath of the attack, his parents sued the Chicago-based Quranic Literacy Institute, an organization which officially promoted the translation of Islamic texts, but also funded Hamas activities. The court was in favor of the Boehm family's claim, which was based on the 1991 Anti-Terrorism Act, and stressed that the only way to imperil the flow of money and discourage the financing of terrorist acts is to impose liability on those who knowingly and intentionally supplied funds to persons who commit the violent crimes. Even without statutes on the point, it's quite likely that the European courts would follow the same path, particularly if claimants could produce convincing evidence of the defendant's intent to support terrorist activities. As highlighted by the American court, though, it must be noted that such a claim can generally only be made where there's funding that meets the definition of aiding and abetting an act of terrorism. It's thus a requirement that the defendants knew about the organization's illegal activity, desired to help that activity succeed, and engaged in some act of helping. If one considers the financing of terrorism and the payments associated with that, then banks and other financial institutions come into view. Doubtless, they can also be liable if they knowingly assist the terrorist organization by carrying out those financial transactions. Moreover, financial institutions are often also subject to a duty to warn the responsible authorities where they draw the reasonable conclusion that a financial transaction is connected to a terrorist organization or a terrorist act. In this context, reference may be made in particular to the European Directive 2015/849, which serves to prevent the exploitation of the financial system for the purposes of money laundering or terrorist financing. However, a duty to report only exists under this directive where justified and objective reasons exist for a suspicion of terrorism, which the institution might appreciate in applying the appropriate level of care. This alone places obvious limits on any possible bank liability. We must also bear in mind that banks will generally only be accused of negligent conduct in this respect. Though banks' statutory reporting duties certainly have the aim of preventing terrorist financing, it will thus only very rarely be possible to hold a bank liable for a particular terrorist act, because the courts will generally deny the necessary causal or attributional connection to the act given the intentional actions of the direct perpetrator. The opposite will only be true, as noted, in the case of genuine assistance. Special difficulties arise in cases where terrorists are supported by sovereign states. In pure tort law terms, the general rules of accessory liability could still found an action without any particular problem in these situations. However, it will usually be the case that such a liability cannot be realized in practice, not only for reasons of public international law, but also simply because of practical barriers to enforcement. The situation here is not always completely hopeless, though, with quite considerable case law existing in the United States, which affirms the liability of countries such as Libya, Iran, or Iraq for terrorist acts committed by organizations such as Hamas. Eisenfeld versus Islamic Republic of Iran may serve as an example here. In that case, the parents of 2 US students killed by Hamas suicide bombers again in Israel were awarded almost 330 million US dollars in compensatory and punitive damages by the US courts. Of course, fault-based liability can be considered for defendants beyond terrorists and their supporters. It can also be considered where parties bound by contract or by law to take preventive measures have culpably omitted to do so and have thus failed to prevent terrorist attacks. The most obvious addressee of such preventive measures is naturally the relevant state. After all, in any country governed by the rule of law, it's primarily the state which has to maintain law and order. This certainly does not mean, however, that the mere occurrence of an act of terrorism will in itself lead to state liability. Instead, a liability can only be considered where the state has culpably failed to protect its citizens against terrorist attacks. This might, for example, be the case where, despite evident danger, police or security services fail to adopt adequate security measures, fail to conduct border checks with sufficient care, or fail to react properly to information received. Even if state liability is not generally out of the question, though, significant difficulties can certainly still attach to setting the relevant standard of care in the concrete case. Though typically there do exist statutory or regulatory regimes describing the state's duty to provide for adequate safety measures in more or less detail, these provisions have to be read in the light of 2 facts. Intentional criminal acts of others cannot be predicted with certainty, and it's flatly impossible in a liberal society to tighten the safeguards in an Orwellian way. Furthermore, we must recognize that all countries have limited budgets and that this is very often leaves the police and other security forces understaffed or under-equipped. Quite apart from the fact that any award would further significantly impact security resources, it will rarely be possible to blame a state for not providing sufficient funds. Comparative legal analysis reveals, meanwhile, that states' willingness to be subject to liability for the misconduct varies greatly. Whilst in Austria and Germany, police misconduct, such as inadequate criminal investigation, leads to state liability, the approaches taken in France and the common law jurisdictions, for example, are much more reserved. In England, the traditional maxim that the king can do no wrong appears to have a continuing effect, a concept which, in my opinion, can obviously have no place in modern society. So, of course, states should be liable too, if they have negligently violated the duty. Alongside the state, private organizations or institutions should also face liability where the duty to undertake safety or security measures has been shifted to them by law or by contract. This concerns private security companies in particular, where these organizations do not properly fulfill the security duties they have undertaken. However, even the organizers of public events, for example pop concerts or sporting events, could leave themselves liable if they fail to take appropriate safety and security measures and a terrorist attack is thus not prevented. Such event organizers are typically bound not only by contract, but also under specific statutory provisions and official conditions to take care in respect of the safety of visitors to their events. The same applies for the owners of public buildings, including, for example, theaters and concert venues alongside sport arenas. The extent of the duties to take care will again depend on the circumstances of the individual case, though the standard of care must correspondingly be set higher where there is a greater terror threat. However, even without the fear of actual terrorist threats, organizers of rock concerts, football games, or other events with large crowds attending will have to screen people entering the location and should be thereby able to detect weapons or bombs. a culpable neglect of these duties that does also lead to liability here. In contrast to the institutions and organizations just mentioned, private parties are generally not bound to take preventive measures against terrorist attacks. Nevertheless, there may be a duty to react or intervene if someone gains knowledge of possible future terrorist activities or witnesses such criminal acts. A failure to warn authorities or lend assistance to victims may consequently lead to civil liability also for individuals. However, such a liability can only be imposed if the action could reasonably be expected of the individual, which depends inter alia upon the foreseeability of the harm, as well as whether the individual would be putting herself in danger by making an intervention. Strict liability. As well as fault-based liability, a second liability track, a strict liability based on a special high risk, falls to be considered in the majority of the jurisdictions. In contrast to fault liability, such a risk-based liability is not concerned with any accusation of misconduct. Instead, it relies on the idea that someone who is permitted to use a particularly dangerous thing for her own advantage should equally bear the risk associated with that. Thus, she should be responsible for damage which results from the dangerousness of the activity. The liability is thus typically concentrated on the so-called keeper of an object. This is, for example, the party who has actual and economic control over a vehicle, but who is not necessarily its legal owner. However, even risk-based liability is not a pure liability for bringing about a particular risk. Rather, there are typically a number of defenses provided for, which range from an unavoidable event, where there is no error in the keeper's sphere of responsibility, to an act of God. In relation to terror attacks, risk-based liabilities for aircraft, cars, and nuclear installations are particularly important. The potential significance of risk-based liabilities for losses resulted from terror attacks can best be explained using a number of examples. A hijacker steers an aeroplane into a building. A terrorist takes someone else's car and purposefully drives it into a crowd of people, or uses the car as a cover for a bomb which later explodes. Terrorists attack a nuclear plant using rockets and thereby cause radioactive contamination. In the case of a hijacked aeroplane or a car, most jurisdictions would not hold the keeper strictly liable unless she could be blamed for carelessly contributing to the hijacking. If a terrorist had therefore taken control over an aircraft or a car without any negligence in the sphere of its keeper, the keeper would be exonerated under most regimes. However, this is not true, for example, in France, South Africa, Switzerland, and the United Kingdom, where the airline cannot avail itself of such a defense and therefore remains strictly liable. If a car is only used as a cover for a bomb meanwhile, no jurisdiction would answer the question of strict liability in the affirmative. The reason is that using a car as a mere hiding place for a bomb is not connected with any operation of the car and consequently involves none of the typical risks of a car, particularly weight and velocity. Similar anonymity in the approaches taken applies to the case of nuclear power plant. Given that such plants are particularly dangerous things, the keeper is typically afforded no opportunity to relieve herself of liability. This applies not only with natural disasters, but also with terrorist acts and other forms of force majeure. In summary, we may thus maintain that the rules of strict liability can certainly lead to some extent to tort claims for victims of terror attacks. From the outset, however, this can only apply in those cases where the terror attack has led to the realization of the specific risk of the dangerous object. There is thus no liability for a car bomb, though there is for a plane which crashes after a bomb exploded, then there would be strict liability. Moreover, liability can only be considered where no defenses are available to the keeper. There certainly do exist serious divergences in that respect, as shown by the comparison between planes and cars on the one hand and nuclear facilities on the other. These differences can be justified, however, given the different level of danger associated with the respective objects. And let me come to my last point, some short words about supplementary fund solution. If neither fault-based nor strict liability can be established, then, in principle, the general tort law rule applies. The loss is to be borne by the person suffering it. Looking at terror-related losses specifically, though, it does seem questionable whether this individualization of the losses is really justified. We might ask whether instead the collectivization of the loss, bearing it as a community, is called for. In this respect, we must of course have regard to the fact that depending on the respective social insurance system and any existing private insurance, the losses will often already be distributed across the relevant community of insureds, and thus that a certain socialization of the loss already takes place. Moreover, many jurisdictions have special statutory compensation funds for victims of crime or, as in the mentioned case of 9/11 and the September 11 Victim Compensation Fund, set funds up ad hoc. Nevertheless, losses suffered by victims will often not be compensated in their entirety, through such means and there are gaps in protection, particularly as regards non-pecuniary losses and property damage. Drawing the nature of a terror attack into view, such gaps in protection do look questionable. It should be remembered that terror attacks, unlike normal damaging events, are not primarily directed at the individual victim, but against society as a whole. The intention is to intimidate or destabilize that society. Hence, it's rightly pointed out that terrorism is characterized by the fact that the attack is symbolic and the real impact is to be on the state. Following this observation about the nature of terrorist-related acts, there should indeed be a general public response to terrorism. If the terrorist's actions are designed to harm the state or the public, injuring the individual victim is only a means to that end. This is an important difference, distinguishing these cases from those where tortfeasor causes damage to one person without thereby targeting another, as well as those involving natural disasters. Consequently, it seems reasonable that the institution which the terrorists really mean to affect should compensate innocent victims who have to suffer as substitutes for the public sector. Ultimately, therefore, the idea that terrorism puts our social systems and the existence of our states at risk, and that it does not primarily aim to injure individuals, is, in my opinion, a convincing argument in favor of establishing a state duty to compensate victims of terror. In other words, it's not simply humanitarian feeling or moral deliberation, but legal principle itself which requires solidarity towards the victims of terrorism. Thank you.
You need the mic?
I think so.
That was really interesting. Sorry?
I prefer a very basic presentation. Thank you to the organizers for inviting me. Indeed, as Ronen has mentioned, this is not exactly my main area. I'm not a tort expert. I would joke that you guys probably know torts better than me, and I know terrorism a little better than you. But it really, it's been really refreshing because since I published a paper about this like 15 years ago, I haven't looked at it I followed from time to time, but I didn't look at it academically. And it was a very interesting experience for me to reread what I wrote 15 years ago. And as always happens when you read a paper you wrote 15 years ago, not the descriptive part, but the normative part, you always have sometimes your thoughts are a little different. So that's where I start. Terrorism has existed in Israel in various forms for several decades. It does change in forms, and it comes in waves. There are periods of waves of terrorism and periods of relative quiet times. And we're going to get a little later into what Professor Gray also mentioned, which is the magnitude of events, because obviously you treat very differently huge events such as 9/11 and much smaller continuous events. So Israel, having to deal with terrorism all those years, has devised comprehensive legislative responses in many areas. Criminal law, constitutional law, and also the compensation of victims. So I guess you can say that some countries export terrorism, we try to export counter-terrorism and legal analysis of terrorism as two areas that are areas that we export. In terms of justification, so because in Israel the protection of victims of terrorism, as in other places, I'm not sure actually that as in other places, has actually, but in Israel it came out of the protection of the compensation for war victims. So the justification given in 1951, when the first law was enacted, was that it is inconceivable that the damage from this war, which was the same law, which we had to withstand, would be borne by individuals and not by the whole public. Not surprisingly, this is very similar to Winston Churchill quote from World War II about how, and this is one of the rationales, that really it should be, which Professor Gray described, which is that the burden should be borne not by the individuals. And I guess to some extent it also relates to something Professor Karner said, because if the terrorists don't really care about who they hurt, and they've hurt, and you happen to be the victim, then that also sort of encourages the same idea. The other factor that should be brought here, and was mentioned a little bit, but I do want to put it already here, and also we'll get to it later in the presentation, is that we tend to forget that the purpose of terrorism is often not the actual harm, but to create fear. And so, because if you look even in Israeli terms, and we're a country that has a lot of terrorism, if you compare the number of victims of terrorism, the number of victims of car accidents in Israel, there's just no comparison. So we're not really dealing with the amount of people hurt or killed, but also with the fear. So when we think of the reason for the government to step in, part of the reason for the government to step in would be to decrease the fear. Now, I'm not sure how much this works. I mean, we have here some distinguished guests from overseas. Each one of you had a member of immediate family or a neighbor saying, "Are you crazy going to Israel? It's really dangerous. What are you doing?" And I can tell you, if you didn't know before, that you're protected economically if something, God forbid, happens to you. Visitors to Israel who entered on a legal visa are protected by our local laws. Now, is this what you would have said to your family member or friend? Don't worry, if something happens to me, I'm protected. I'll get a host of benefits that will be listed in a minute. Not sure, but in terms of the theory, we do need to put this inside the theory. So when we go to compensation for harm, Israel has a permanent system of state compensation for harm caused by terrorism. The compensation is actually equal for civilians harmed by war and civilians harmed by terrorism, which is important because we don't always know how to distinguish, actually more in recent years than before. We're not really sure how to distinguish one from the other. And there are really two schemes, two complete schemes. One is a scheme for compensation for bodily injuries and for family members of deceased victims. And the other is a compensation for property damage. And they each have their own laws. I'm not going to go into a lot of details of those schemes, but a lot of my article from 2003 was exactly that, detailing exactly what are in the descriptive part of the article, it hasn't changed a lot. So in terms what it is, and I'll mention some of the changes later. So I'm just really to save us some time. So just just the headers, medical care, a living stipend to injured victims that can't work for a while, some sort of a disability compensation. And the question we should ask is, we should look at, because one of the things we're going to keep looking at, I guess, all the time is some sort of an horizontal equity with others. And I'm going to, Professor Gray, mentioned a few of those horizontal equities, and I think there are a few more, and I'm going to mention a few more. But we'll keep looking. Why do these people get it and others shouldn't? And so I think that it's interesting to look at it. And one of the things that we also should consider when we look at various countries' responses is what's actually the social welfare policy of the country as a whole. Because for example, one of the first benefits listed in the Israeli compensation scheme is a burial payment. Well, a few years later, Israel decided that all citizens are entitled to a burial payment. Israeli citizens don't need to pay for burial anymore. So it's no longer important to provide the burial payment to victims of terrorism. And if you look at it as a safety net, not as we should split the cost, all of us, but if you look at it as a safety net, then if the country has a really good social welfare safety net, then you don't need to provide it as part of the state aid. If the country has, as Israel does, a decent state-mandated health system, then it's less important to provide hospitalization benefits, etc., except, again, in this case, for people who don't enjoy the Israeli health system. For example, if there's a tourist that needs this assistance, but in terms of the budget allotted for that purpose, you don't need to put a real budget, since anyway the state is giving this. So there's a bunch of additional benefits. Some of them I'm almost embarrassed at reading, but this is Israeli culture. This is Israeli culture. The Israeli culture, if you look at a payslip of an Israeli, there's going to be like 20 lines, and he's going to get benefits for this and benefits for that, benefits for that. And then when I went to work in America for the first time, and they told me that's your salary and that's what you get, it was very weird to me. but the Israeli culture is such that you get a lot of small benefits. So just look at the next to last item here. You get grants for clothing, a yearly clothing grant, a heating or cooling grant, college education for your children when they get to college, a grant for your marriage. There's like a lot of small things. Some of them are more, more normal, but home purchasing grants and everything. And there's also tax breaks. So there's direct assistance, there's indirect assistance in the form of tax breaks. And in addition to these are the benefits, there's also compensation for the relatives for the relatives of the deceased victims. And here, note something again when you compare it with ordinary tort law. In tort law, you'd think of either the estate or in some cases you'd think of dependents, right? So here you don't only think of those, because when you think of the parents of the victims who do get a monetary award in Israel, sometimes they may be dependents, but the way that it's designed in Israeli law does not depend on them being dependents. They just get it for being bereaved parents, which is actually, again, copied from the military system. And the military system, don't forget, most of the soldiers in active duty in Israel are, the mandatory army duty is 18 to 21, so the parents are much more involved in the, often there were no spouses. So it made sense, but that's the system that was created for the military, and the system that was created for the military was copied completely to the system for terror victims. I'm not sure that if the state system was to be redesigned, I'm not sure that it should be designed this way, but I'm gonna, at the end, when I talk about the advantages and disadvantages of a permanent scheme, here's one big problem of a permanent scheme, at least in Israel. I don't know about other countries. These are untouchable rights. There's no way politically that any right that is given under this system will ever be diminished, ever. So when you think of, and it actually will go the other way, and I'm going to try to demonstrate that. So when you think about the disadvantages of a permanent scheme, if you come from a country where the government is able to design its social policies based on political aspects, etc., and budgets and priorities, well, this is money that you earmark. Forget about it. It will never go down if you take this way. Then we have the compensation for property damage, and here actually we went from a rationale perspective. We had a shift, because in the beginning this was really a sort of a forced insurance scheme. Okay, if you owned real estate, there was a tax levied on your real estate, and if you owned a business, there was a tax levied on your business, and when war hit you or terrorism, you'd be compensated. So it was a forced insurance, but that's how it came. And in fact, the name of the law, the original name of the law was Property Tax and Compensation Law. That's the name of the original law. And sometimes afterwards, the link was really broken, and we lost the tax, which again, if you think about it from a tax perspective, tax policy perspective, Israel decided to do away with property tax, basically. And you can think of the distributive results of that, but still to use the funds that the state was giving based on the original property tax to compensate for property damage. And here, again, not going into too many details, and you'll find most of the details in the old paper from 2003, the only compensation is for damage to assets. It's for damage to assets, and there is some compensation for indirect damage, but most of the indirect damage is only given to people in border settlements. The government has some ability to change that under special circumstances. But that's the way it goes, and we'll get in a second, using an example, we'll get into what it means. But basically, the losses that are not covered are, first of all, the indirect damages of victims, and there are a lot of those, and there are all damages of the indirect victims. For example, if there's a couple of well-publicized terrorism attacks in Israel, you can expect the tourism industry in Israel to suffer. And there is no way under current law to provide them with any assistance, even though maybe their damage will be much higher than the damage of somebody who was, I mean, think about it, high publicized attacks, 2, 3, 5 people killed. This is horrible, but in terms of monetary damages to property, not that much. But if the industry, if thousands of people cancel their trips immediately after, hotels, airlines, restaurants, tour guides, everybody loses their work. And these basically right now are not going to be compensated. And sometimes you get lucky. And I don't know how much our guests from out of the country are following Israeli news in the last couple of days, but our Israeli guests will know what I'm talking about. But sometimes when you're an academic and you're looking for an example, it falls from the sky. And here it is. The latest act of terrorism from last night. This is a headline from yesterday. Okay? So as many of you know, the Argentina soccer team decided to cancel its visit to Israel, and the Minister of Culture and Sports has spent a lot of time yesterday to explain that this is an act of terrorism. Okay? Now that raises, I'm gonna use that great example that if you were looking for a reason for it to happen, it's this conference. I'm going to use this example to start playing a little bit with the Israeli definitions and to see where we should go in terms of policies. So I mentioned that basically Israeli law covers for proper damage to property caused by an act of terrorism, right? So do we have property here? Should the state compensate the games organizers? Is that the games organizers, this was actually a private endeavor. They lost a lot of money. I'm not sure it's an asset. Might be more of an indirect damage. However, if I bought a ticket, then maybe I have something of value. Israelis were fighting for those tickets like crazy. There was much more demand than the number of tickets allotted. So the ticket must be, maybe it's property, and the state should compensate. The government just announced that it was an act of terrorism, so I'm allowed to compensation. But better yet, what if I bought the ticket from a scalper? Okay, the ticket itself only cost 50 shekels, but tickets were going for 1,000 and 2,000 shekels in recent days. So if I bought 4 of those, this is a lot of money. And in fact, in terms of going to regular channels of law, it's going to be very difficult for those people to use contract. I mean, the people who bought a ticket from the organizer should be able to get back their money from the organizer. If you bought a ticket from a scalper, good luck. You know, with getting your premium back. No way. Maybe the scalpers who got stuck with a bunch of tickets that they haven't sold yet. Maybe that's property. I don't know. So sometimes definitions are not so great. Definitions don't, and when you try using a permanent scheme to draw lines, then one of the things that we can learn, I think, from this example is that the lines don't always get drawn in the right place. So that's one thing. The other thing which is very interesting in what happened yesterday is, and that's again something that arose a little bit in Professor Gray's talk, is the fact that various parties here have a vested interest in navigating a specific event into whether it's a terrorism event or not. Now, sometimes, obviously, there's no doubt, right? 9/11, there's no doubt that it's a terrorist attack. But we find, and in Israel we find it quite frequently, that events are being disputed on whether there are or not. Minister Regev had a clear political interest in declaring that this was a terrorism event because that's the only way that gets her out of this somehow clean. Otherwise, and again, I'm not going to get our guests into this, but the Israelis know about what I'm talking about. Some political decisions and maneuvers along the line were the ones who caused it. So it's either a political failure or an act of terrorism. If you were a politician, which one do you choose, right? And that might happen more than once. So that's an issue, but it's not an issue only with this great example from last night. It's actually an issue that arises a lot. Victims would usually have a significant incentive if there is a compensation scheme. Look how it changes. If there is a compensation scheme, the victims have an incentive to say that it was an act of terrorism. If there wasn't an incentive scheme, then, and if they're insured, they have all the reasons in the world to want to say it wasn't an act of terrorism, because most insurance policies have a terrorism exclusion. So, and that's again something that you need to look when you look at the whole picture. How about the assailants? Well, again, if they're a member of a terrorist group, then it's a no-brainer. But what we've had a few times in Israel in the last few years is people driving into a group of people with a car, similar to some of the stuff that's been happening in Europe. But in Israel, often they try to claim that they just lost control of the wheel, right? Now, here, again, they need to choose a little bit where they go, because they don't care about their monetary responsibility. They do care about what they might get as a criminal punishment. They're more likely to get a much higher punishment if they drove into a group of people for terrorism reasons than if they just lost control of the wheel. On the other hand, given Israel's really bad experience with what Israel does with terrorists after a few years, they're in a good shape to be released quite soon. in the next exchange of prisoners if they declare that they are part of a terrorist organization. In addition to that, I think that this is unfortunate, but their families will be better off because, unfortunately, as you may know, Palestinian Authority is sponsoring the families of terrorists. So you're basically, if you're just a criminal or a bad driver going to jail, your family gets nothing. If you're a terrorist, your family gets a monetary payment. So the dilemmas here are not so simple. And a third player here is the insurance company. Because Ronen, you mentioned the British example with the car driving. Again, I'm not a tort person, but from what I remember from the Israeli no-fault system for car accidents, actually an intentional act is excluded from the no-fault. Right. So if the person so you have three options here. If the person was a terrorist, then you're covered by the Victim Compensation Fund. If the person did it on purpose but wasn't a terrorist, you're not covered by anything. If the person wasn't a terrorist and wasn't doing this on purpose, you are covered by the no-fault accident scheme, which I think, I don't know about England, but I think in Israel is actually, in most cases, will be less good than to be covered by the victim compensation, by the permanent victim compensation fund, unlike the British example that you mentioned. So, and of course, what's interesting in the actions of all those actors is that they're not coordinated. They're not coordinated, but sometimes they're on the same side, and sometimes they're not on the same side. This is, I think, highly unusual. When I tried to research this, I saw that, for example, in the U.S., your criminal punishment is higher if you didn't just murder somebody, but it was a hate crime, right? If it was a racially motivated, it becomes a federal crime, and you might get a higher punishment. So there was sometimes the same debate over, but you didn't have two sides. You didn't have, and here sometimes you have the families. What is very clear in Israel is that often the families, especially of deceased people, will always go to the option that it was a terrorism act, not only because of the monetary compensation, but it's much better in terms of the public eye to have been a victim, that your family member has been a victim of terrorism, than he's been a victim of just a random criminal act, and there's always questions that arise on this. So a few things. One of the things I didn't deal enough in the old paper, and I think needs to be dealt with more, is really the role of insurance companies in this. So we start with the problem of exclusions, and whether maybe the state should prohibit exclusions. Maybe a state that is under a state of terrorism, and remember that the reason the insurance companies exclude terrorism is one of two things. It's A, because they can, right? Because there's not enough competition, because there's no reason for it. We just discussed that the number of people affected by terrorism is not so high, so why does my life insurance prevent me from being compensated? And the other is something that is more acceptable, which is a catastrophic event, right? If there is a catastrophic event, maybe the insurance company. So maybe by way of some sort of, and I think, Professor Gray, that again this relates to something you mentioned, that maybe the government can just, with a much lower risk, take a position vis-a-vis just the catastrophes, not vis-a-vis the day-to-day, and force the insurance companies to be there. Should there be a compulsory insurance? Because don't forget that when I'm a homeowner, and let's assume that my home is not far from here in the Carmel, and I have to think about the possibility of a fire, right? And so if I'm a person who don't care, then I don't insure my house, and then it's my problem once there's a fire. So if we were just to handle things from the insurance side, then people who care, people who actually would buy insurance against a variety of risks, would also be insured, and people who decided in advance that they couldn't care less wouldn't be protected just in the case of terrorism, just in the same way that they wouldn't be protected in another event. And again, I think a little bit about the horizontal equality. What I'm talking about now promises horizontal equality for victims of terrorism vis-a-vis victims of other acts. When you look at the property damages, actually there is one very important effect of the back to normal life, right? Because if you just took, if there's a large area that's been affected, some businesses were insured, others weren't insured. Anybody who's ever dealt with an insurance company knows that the insurance company does not come immediately to help you. They check your claim, and they use all the time that they're allowed to check your claim, and then they recheck. They really need to check it very well. And so the advantage of the state estimators coming immediately, dealing with it, it's also more efficient sometimes, because in Israel, when you have a whole area affected by, say, rockets, often the state would contract with the same contractors to do all the work in a certain area. You'd need, instead of contracting 50 different people who can fix the glass, the broken glass, you'd have one person coming with a truck and doing it in one day. So that could actually be sometimes also more efficient. So if I look at some of the advantages of a permanent scheme, I think that in general, a permanent scheme is more likely to decrease inequality between similarly situated victims. Just imagine, and Professor Gray mentioned that the 9/11 fund was to a large extent the result of the desire to save the airlines. Just imagine if the terrorists of 9/11, instead of using airplanes, decided to just put in the parking lot of the Twin Towers a bunch of trucks and detonated them at the same time, which they've tried to do, by the way, with the trucks a few years earlier, just with one rider truck. So nobody would have wanted to save the truck industry in this case, because nobody would have sued the truck industry. It's just a bunch of trucks. And so we would have had a completely different system. And when you look at horizontal equality, I don't think that your fate should be determined by the question of which industry people are trying to save. There's the story of magnitude of events. Now, magnitude of events does determine in the case of the US, it's clear that the magnitude of the event was one of the things that caused the, because again, there wouldn't be an airline, the need to bail out the airlines if the event wasn't so huge. But here, I must say that I'm a little less sure that this is the right thing, because we tend to react differently to huge events anyway, right? We would, if we heard about somebody's house burning, we might feel sorry, personally, but the chances that we'll start raise money and furniture and stuff like that is not as likely. If we hear about Hurricane Katrina, suddenly then the government is more likely to send help, and also the public as a whole is more likely. So we always treat differently events of a large magnitude. I do think that even though under the circumstances the decisions in the 9/11 Victims' Compensation Fund were remarkable in how well they were made, that this is not the right way to make decisions. Decisions are better made if they're well thought, if they're not made under pressure, if you can design the mechanisms as doing hearings and everything. If you don't have people with vested interests, right? It's much easier to decide how to distribute between the high earners and the low earners if you don't have an actual lobby of the high earners who are actually already dead, and it's their lawyers who are the ones hitting you with, no, you shouldn't, you should compensate us much more. It's much better to do it on a theoretical basis, etc. There's obviously the cost of administration, and if you go to the issue that Professor Karner mentioned of going after third-party tortfeasors, then maybe the government is better equipped in going after, in some cases, after those organizations and even foreign states. And if the government gets some sort of a subrogation right based on the fact that it compensated everybody, maybe looking at the picture as a whole, this would be more efficient. When I look at the disadvantages, obviously the cost of operation of a permanent scheme, as I mentioned before, untouchable rights, and there's a tendency not only to not decrease rights, but also to increase them over time. So we've had two, actually three, I think, very broad enhancements of who is covered under the Israeli scheme in recent years. So first of all, an interesting one, I think, analytically, is the following. Assume you're an Israeli and you got into a terrorist attack in Nice, right? In Nice, France. Okay? So you, under the law as it existed until 2 or 3 years ago, you wouldn't be covered because that we have nothing to do with it, right? The only way you'd be covered is if the terrorist attack was aimed at Israelis or at Jews. If the Israeli went to a synagogue and was attacked in a synagogue, he would be covered under previous law. But what the law says now, as of last year, is that if the terrorist attack outside of Israel was done by an organization which has declared itself to be against Israel, you're covered. Not that the terrorist attack was against Israel. The organization is against Israel. So if you're attacked in Paris and you happen to be attacked by ISIS, you're covered because ISIS, among its many other purposes, also is against Israel. So you're covered. But if you were attacked by some sort of an Islamic group that didn't declare, or a non-Islamic group that didn't declare itself to be specifically against the state of Israel, you're not covered. So again, horizontal equity, but we broadened what it was before. The other broadening, which is interesting because it was actually something that increased equality, is that under Israeli law now, if you're a victim of an act of violence resulting from the Arab-Israeli conflict, that's the way it's defined. It's really a special case of a hate crime. And it's good because it actually was meant to cover some of the Arabs that became subject of some Jewish terrorism. And so that was added in because it wasn't clear enough that the definitions were covering it, and some applications were rejected, so the law broadened it. But the last example that I'm going to use will show the slippery slope in this. A couple of years ago that we had the big fires here in Haifa? When there was a wave of fires in this area, and there were mostly accusations about the motives of the people who set those fires. Because as you know, it's not always easy to find who set the fires. It was hot. The fires, even the people who were caught setting fires, which is, again, not so easy to catch them in the first place, usually preferred to claim negligence. I threw my cigarette, I had no idea what's going to happen, than to say, no, I wanted to set a fire. And there was a lot of damage to houses in Haifa. And very quickly, the government really realized that it had no choice politically. This is not legally. But politically, the government had to recognize all the fires as suspect terrorist acts. Didn't say they were terrorist acts, but as suspect terrorist acts, and to provide the compensation to everybody, okay? Which is what this analysis that I've put here, the headline is that really the wildfires have been extended, and from now on, this is the way it's going to be with every big wildfire in Israel. There's no going back. Remember, that's part of the problem with the permanent scheme. You've done it once, there's no way that you can do it, that you can go back and say, okay, from now on, wildfires we're not covering, except if we know that it's actually a terrorist who said them. No way. Politically, it just doesn't work. So, although there are a lot of advantages to a permanent scheme, I did want to point out some of the disadvantages. Thank you.
We'll take some questions. Yeah.
So let's see. Regarding
Turn it on.
Okay. So about your talk, I wonder how it's connected or maybe connected to the lack of need for a license for guns, meaning the American government is not restricting a very, very powerful tool
very, very available for every terrorist. And perform such an act, and as terror becomes broadly defined very easily, it seems like a very basic conflict of interests for the government, and should it come hand in hand with your suggestion?
So, you know, I'm a believer in gun control, so it's not about that. But
True.
I'm a little confused. I think the terrorist attacks that have been prevented in our country, and obviously 9/11, really didn't involve that kind of gun violence. It was a lot of bombings and aborted bombings. So I'm not sure.
Recall this Florida club, like
Yeah.
1 year ago.
Right.
It could naturally, it was described as
An act of
terror
terror.
attack, and I guess it was bought in, I don't know, Toys R Us.
Right, right, you're right. So a problem that we have is that gun control is very decentralized, obviously. So it's all very state-driven, and I live in a state, Arizona, where guns are celebrated and they're everywhere. So it would take a real strong act. You know, the federal government obviously has the ability to do that, but take a very strong government to bypass those kind of states' rights that seem as traditional there. And so I don't know what gun control is like here in Israel, and has it been effective? I mean, I guess I don't know the counterfactual of
You-
this. Yeah.
Yes, you should prove that you are sane, and typically it's for post-army veterans. But
So it's pretty minor, or,
so it's restricted in a sense.
right?
But you should have a definition for what normality is, which is
Right.
challenging.
But school shootings
Oh,
are basically terror activities. They are not regarded,
it
I think,
depends
as
on, as you pointed out, what your definition of terrorism is, and certainly not an attack against the state when those kids go in and they emulate other kids and start shooting in schools. So I guess I under, I think I'm gonna borrow your definition, I don't see school shootings as an act of terrorism in that sense, as a,
Given a generous new policy, to make sense to many parents, maybe to demand it. This is where my question.
I felt that the conversation earlier was primarily about international terrorism. Simply because in the U.S. that's sort of where the government wants to draw the line. And even in 2002, when there was the LAX shooting, which was a lone individual who was motivated by the same concerns that international terrorist groups have, to say the least. It took the government still several months, the FBI several months, to decide if this was an act of terrorism, simply because it didn't fit into the traditional rubric that American counterterrorism people thinking.
right. So, right, and I agree that that is how we distinguish.
Right,
It's
and by the
exactly-
standard of international terrorism, I don't know if any of them have really, even the Florida case was really more domestic, right? I mean, it's similar to the LAX case, but I don't know if there really are any major gun cases.
I'm trying to think of them, and I can't think of them. I mean, it's obviously a tremendous problem in our country, but I don't think that we think of them as, I think we distinguish them in our minds as,
it's a political distinction.
yes, it probably is. It probably is a political distinction. And frankly, it has to do with who the perpetrator is. It's a 18-year-old kid going in there and shooting his classmates, and so we don't see it the same way. And maybe it's just a political distinction.
Other questions? Okay, go ahead. Need,
Question for Hillel, and maybe Professor Karno would like to comment on this as well. In your response to Betty and the suggestion to rely on standing funds, like regular funds, you raise the argument of untouchable rights.
That's actually against the untouchable right is an argument against.
Against, yeah. So, as far as I understand, it's not a legal or moral argument, but a political one, and I mean untouchable in a political sense. Like politicians wouldn't dare to change, to reduce the amount.
I mean, I'm bumping into Eli's one of Eli's areas of expertise. What I'm trying to say is that I would like in a normal country the public to be able to set priorities, go into elections, and select where its budgets are going, right? So, and I think that here what happens is that once you get into this, on my way here I looked at the figures. So I only have the figure. I don't have the figure for the property damage, but I have the figure for the bodily injuries, which is administered by the Social Security. It's 500 million shekels every year. That's the amount. It's a lot of money. It's really a lot of money. And there's no way that somebody, just giving you a few examples, very stupid examples. There's a telephone allowance, okay? If you've ever been hurt in a terrorist attack in Israel, you'll get a few shekalim every month for a telephone. It's not justified. You shouldn't have it. Now good luck trying to have the Knesset repealed. You need to repeal the law. Good luck with that, trying to do that. You'll get articles in the paper, they're taking away my telephone, it's my, and it's ridiculous. But it won't be touched. So my problem is with the ability to set priorities. And once you have, again, it was mentioned, I didn't know that the Victims' Compensation Fund didn't have an amount. I thought it had an amount and it had to play with. I didn't know there wasn't a ceiling. Okay. No, but in my very humble opinion, I think that the state in those cases should say, here's the budget, here's what we decided. Because remember that this budget is going to be taken from, in a country like Israel, from building another hospital, right? And not building the other hospital is going to kill a lot of people, right? So you're just choosing between those choices are what I think that the permanent fund is determined.
Right, but it's a practical argument with regard to the political system, the Israeli political system, right?
I don't know if it's only in Israel. I mentioned when I mentioned that I said I knew it was right for Israel. I think in most countries that have more of a developed social network in other things, if they have health benefits, you'll see the same thing. Every year in Israel, and I'm sure it's the same in other countries, you'll see health benefits increasing, right? In countries that provide health. You'll never see, okay, we've decided that we're taking dialysis out. It's not going to happen, right? So that's the problem.
Well, it's culture dependent, right? If the political culture is different, then the whole array of incentives and decision would be utterly different.
Maybe.
Okay.
Don't forget that Obamacare was repealed.
Right, but that's a little different.
Yeah.
Not a question, just an observation. Especially what Hilary Sommer said. I learned that the question of compensation has become a kind of rational choice game. So among many participants, not just the victims, the direct victims, but many others. And if this is so, then the question arises that what does it mean for the society if terrorism becomes just an what's that? Oh. If terrorism in a way becomes something like part of normal life, like car accidents, suicides, house burning, or whatnot in civil life. So it is. So my question is finally a question: is a society in good shape if this happens? If they can integrate terrorism as just part of normal life, or is it a sign of a deeply, how should I say, insane, or how should I say, society, or a society which is which has some pathology. So just an observation. I have no answer to that question, but it strikes me as something very special for at least what you said about the Israelis.
But what do you do with our crime compensation?
I was going to say that. I was going to say, do you say the same about
Is
crime?
that also
Murders.
murders?
Just substitute terrorism with murders. Then what? You tolerate that, right? You tolerate that there's a certain amount. And remember, some countries, some places like New York, you know, under Rudy Giuliani, went a huge decline. When you decline, what if it goes the other way, right? Do you accept it, or do you? It's the same. It's really the same. There's an illusion with terrorism. One of the justifications for terrorism, which has come before, is that maybe if you think about classic rationales of tort law, you think about fault. You know, fault of the victim, right? Should the victim have done X, Y, Z, contributory negligence, everything? So. In Israel, there were a few cases where parties were trying to claim contributory negligence against victims of terrorism. And the court was very, very mad about even raising the argument and said no, because we're treating it like some sort of an insurance scheme. So insurance companies usually can't raise contributory negligence, right? So that's very bad. I think that this is why, but I think again, I think your question is a great question. I'm not really sure how much the compensation scheme is the one that determines it, right? It's not. You want to know how normal it is? I'm sorry I didn't put this in the presentation, but a month ago I went into a doctor's office with my mother, and when I entered the building, I saw that on another floor there was something called a club for victims of terror. I'm not kidding. Really, this is the Social Security in Israel. As part of its activities, it's created clubs where they can come, meet each other, get some sort of services, but just the notion, in terms of normalizing it, that you go into a building and there's I have a picture of it, and you have a club for victims. Yes, it's normal. It's part of our life. It's completely part of our life in Israel.
Well, I didn't mean to criticize that.
No, I didn't take it this way.
To give just a comparison, I mean, a society which would say, we want to abolish crime altogether. No crime in our society.
Zero.
Then we see that's crazy. I mean, crime is part of life. Because there are many reasons I don't go into that. But if you say the same from terrorism, then I want to remind of what Eddie said about how he defined terrorism. There is always the intention, the collective, in a way, political intention to create disaster in a society. And therefore, I think if a society says we want to abolish this kind of disaster, I think it would be understandable, and I would accept that. But now I learn, no, more or less it's the same as if I claimed we want to abolish crime altogether. It has the same status as crime. So I just want to clarify the status of what we are discussing. No more. I don't mean to criticize or.
No, nobody took it this way. Listen, I think let me. I'm rethinking. I'm not sure if I'm really qualified to give you the answer, but I think that in Israel the answer to your question will be a political question. And I think, and please help me, the Israelis around here. I think that the Likud government will say no, we're not willing to accept any terrorism. We'll keep going after terrorism until we reduce it to zero, right? And if you look at some of the left in Israel, assuming we have a left, then the left would say, we're willing to take all sort of risks and go into some sort of peace agreement, but we realize that you guys from the right are right, there will be some terrorism, but we're willing to tolerate a certain level of terrorism because we want a chance of peace, right? So I think, and again, please feel free to express other opinions, and in Israel it would be a political question whether we accept terrorism or we try to fight it to a level of zero all the time.
And I just want to add to that. This morning, that Admiral Alayon, that's exactly what he was arguing, really, that we need to start.
He's part of the non-existing left wing.
Right. I got that. But that he said that we really have to reframe our viewpoint, and that really we need to going to tolerate a low level of terrorism and that it will become like crime and we'll never eradicate it completely. So your point is well taken, I think.
Just two comments with regard to what
But not questions, Ellie. We are 25 minutes behind schedule, so just comments.
Just comment. I think that statistically, if we examine how many victims of terror we had in Israel since its establishment, we find a very low figure. Comparative to victims of crime in the US or South America, the number of victims of terror in Israel is very small. So it is a political thing. Politicians make terror a real political board to promote their ideologies on one hand. But the other thing, which is the paradox, is that the terrorists are much less effective in Israel. One terror attack in Paris changes dramatically the scenario of French life for many years. Terror here is part of it's part of normality, and part of normality which is manipulated by political forces. So there are good things and bad things about this kind of normality.
Okay, so I'd like to thank everybody here. Thank you to our visitors and to our to the other centers, the Minerva Center headed by Ellie, the Cyber Center, and of course the Astrovitzer Center for organizing this event. And we will continue the talk later.
And we have to thank Michal,
yeah, of course,
and Yoni,
And then I would just
and Eran for the great organization of this meeting.
Yeah, thank you.
Okay, who's for the taxi to the